what do you think could be the advantages or the pros of these provisions? Classified what offences?
There are discrepancies. There was the necessity of incorporating this provision under the BNSS Act. There is no provision to challenge this aspect. Probably there should have been more debate on this aspect. I think it is going to delay the process.
Again, one more provision giving more power to the police.
Yes.
Hello everybody, welcome to the first episode of Bridging the Gap presented by Advocates Association of Western India, AAWI. The association has decided to start a podcast series for all of the members of the bar, members of the fraternity, and even otherwise all persons who are interested in various legal topics, so we can create awareness and in the sense bridge the gap between the seniors and the juniors, the bar and the bench, people from the field and people outside the field, and so we can spread as much knowledge and legal awareness as possible. Today's episode is regarding the Bhartiya Nagrik Suraksha Sanhita 2023, the BNSS, or more commonly known as the new CrPC, the law which deals with various practices and procedures of criminal trials, criminal prosecutions all over the nation. My colleague Bhumesh Bellam and I welcome Honorable Justice P D Naik, former judge of the Bombay High Court and also recently designated as a senior advocate of the Supreme Court. But above all of these rather great achievements of Justice Naik, he is truly a gentleman, a friend to all, and his benevolent approach has always made every lawyer, junior or senior, feel it to be a privilege to appear before him. So I would really welcome you, sir.
First of all, I am very glad that the Advocate Association of Western India has started this program. The theme of this program itself is very encouraging, that is bridging the gap. Now, as a lawyer, I recollect that in 1986, I joined this AAWI. I began my profession in appellate side of the Bombay High Court. And as you all know, I initially began my profession with Shirish Gupte, senior advocate. To be frank with you, I didn't know anything about this legal profession. Being a first generation lawyer, I had never visited court. But then after joining the profession, the encouragement in the chamber and the learning from the various senior members of the bar had brought me wherever I am today. So my gratitude is there for all of them to be here. Now I'm very glad to interact with the two junior members of AAWI. This is the way it should be. But this is a good program. The theme of the program itself indicates that you are the right persons, young generation boys who are here. And the topic is also interesting, which is a boiling topic. In fact, wherever you go, you will find out how to interpret what are the changes in this new law and how it should compare with the old law and how it is going to be effective for imparting justice. All these aspects will, of course, we'll be discussing in this podcast.
Diving into the topic,
Yes.
the BNSS or the new CrPC. I would firstly like to know your general overview about this legislation, the BNSS, and also do you think that it is actually reforming the criminal procedure system in general?
See, there are three criminal major acts. One is IPC, Evidence Act, and the Code of Criminal Procedure, which is now named as BNSS.
Yes.
Now, IPC, it was brought into force during British period only by Macaulay.
Yeah.
And Indian Evidence Act was enacted during the British period. But CrPC, we made a change, brought a new CrPC in 1973. But IPC and Evidence Act continued. We made certain amendment in IPC, even in the Evidence Act, but major part of IPC or Evidence Act, you will find it has continued. There are no major changes. But in 1973, we felt that it is necessary to bring a changes in the procedural law, which is to be followed in the criminal courts. And that's the reason the 1973 code came into force. Now, what is the need of bringing into force this enactment of 2023 BNSS? That is the question which we have to discuss. If you see the statement and object of BNSS, you will find the motivation for bringing this legislation into force appears to be is that speedy justice is one factor which appears to have been considered, and the law should be victim centric. That is also tried to be brought into taken into consideration. And looking into this statement and object and the provisions which are brought in in BNSS of 2023, you will find that there are certain changes which are, whether they will be effective in achieving the goal for which these legislation has been brought into force. It's a different thing which we'll have to test it.
Sir, starting off with few of the changes, because that's the basis of this present podcast. We are focusing on the changes which have taken place in the BNSS.
Yes.
Certain futuristic changes have been incorporated, such as the use of audiovisual and audio-video methods, wherein statements can be now recorded by way of audio-video, and also summons can be now given through electronic means, or even production of documents can be done through electronic means. And more than that, even search and seizure, there is a provision to record this entire process of search and seizure by way of audio, video, and mobile phone, etc. Sir, what are your views on this particular aspect, and what do you think are also the shortcomings for such an audio, video, knowing artificial intelligence and also deep fake, etc., which is growing by now? So what are your views with respect to this being a futuristic addition to the BNSS?
See, the world is changing. The electronics is playing a major role nowadays.
Like this episode.
Yes, everyone has been using electronic means. Now, if you see this legislation, the use of electronic means has been taken into consideration for carrying out various aspects of investigation. Now, this BNSS, you will find there are specific provisions which have been made for the purpose of investigation, which is going to aid the investigating officer by using certain devices. There are two major definitions which have been incorporated in this new legislation. One is electronic communication, and the other one is electronic means. So based on these two definitions, you will find there are provisions in this BNSS as to how these two devices, how these means are being utilized for carrying out effective investigation. In the olden days, you will find that, for example, recovery is being made. Recovery is governed by statement is made. This is an exceptional aspect, that when a person makes a statement of commission of crime which leads to recovery of some weapon, for example, under section 27 of the Evidence Act, you will find that recovery and discovery aspect. And then he goes before the court, he admits that I have I have used a particular weapon in commission of crime. He goes to a particular place, and then the weapon is recovered. This is what is being done, and Panchanama is recorded. It was easier for an accused to deny that this is not happened. But by electronic means, probably the idea is that the search and seizure is being conducted, they are going to record it. Video record it. And use of mobile phone has been specifically referred to in certain provisions. So this is the way probably the idea of utilizing these electronic devices is to make the investigation more stronger. Now see, electronic communication and electronic means. Electronic means which is to be utilized, means electronic devices which are to be utilized by the investigating agency for conducting investigation. Like we have just now said, that statements can be recorded, statement under section 164, confessions and statement. In fact, 1973 code also has that provision, but that was brought subsequently in 2009. There was an amendment to that provision, and 164 was amended, and they have incorporated use of electronic means is there also. It is also here. Other than that, even summons, there is a use of electronic. That summons which has been used, electronic evidence can be brought before the court that a summons has been issued, communicated to the person, and that is admissible in evidence. proof of electronic devices. There's another provision, section 63, section 70, section 94,
Yes.
subject to correction. These are the basic provisions which deal with this aspect of. So these are the provisions, basically the use of electronic devices has been made particularly to strengthen the investigation. And therefore, it will be a very difficult time even for the accused to deny this aspect, because it will be recorded unless there are, every accused, there are various defenses, and the able defense lawyer always will try to see that the whatever evidence which has been brought by the investigating agency has to be demolished. Other than this, you must be knowing that in Indian Evidence Act also, the proof of electronic evidence also will be as the rest. We are not discussing that topic. Otherwise, that is also will be an aspect. If we discuss any topic on Evidence Act at any point of time, we'll have to consider
65B certificate.
65B
Yes, we'll have to.
certificate, and whether it is admissible in evidence. All those aspects, of course, will come. But this is a test now. The law has come into force now. Slowly we'll find, because the courts have also not dealt with so far. Now the offences are being registered, and as and when any issue of interpretation of law, admissibility of evidence comes forth, the court are bound to decide those aspects.
Over here, they have not really given a unified system all over the nation for recording this footage. They said including mobile phones. So now, if there's no transparent system of recording all of this investigation, I feel there could be some sort of misuse, or Bhomesh mentioned deepfakes or AI. That is something which we don't know. That again, like interpretation of the law and how it will work. But we don't know how it will be used or misused by the...
Like, just see, there's something called a defense for alibi.
Yeah.
Now, technology has gone to such an extent that there's a group photo.
Yeah.
And even if you're not in that group, you can be inserted by
Photoshop.
manipulation to show that you're that in that particular photograph. It is easily being done. So such aspects, of course, as you rightly say, they are bound to come. Like deep flakes or AI, one doesn't know what is going to come. So such issues. That's why I said the defense lawyer is bound to take benefit of all these aspects, and will see that it is created, false, and manufactured by the prosecuting agents. And there are also, of course, chances of even manipulating.
Yes.
We always see that sometimes investigating authorities also, they all do manipulate the things and sometimes falsely implicate the innocent persons.
Also convenient recording. You record some part, you don't record some part. That can be possible. Earlier we are like, also there can be a dichotomy between like the panchanamas recorded and the videos actually recorded. So there can be changes in that as well. So.
That effective cross-examination is going to help.
Of course.
So another topic, very interesting, because the topic of 107 of the new BNSS about attachment of properties, and not only attachment but distribution of the properties. 107 has given a wide power.
Proceeds of crime.
Yes, proceeds of crime. This we had seen before in MPID under PMLA.
PMLA it is there.
Yes. So, but over here, what I see is that attachment is a power given. They have not classified what offences.
There are discrepancies in that particular provision. There is no procedure, proper procedure has been incorporated. Plus, what would happen ultimately if that person stands acquitted?
Yes.
In that particular, there is no provision as to, and what is being provided here is that if it is found that that particular property has some connection, or it's out of the proceeds of crime, it can be attached, and notice is required to be given. 14 days notice is required to be given to the accused person whose property is to be attached, etc., and it is to be distributed also.
Yes.
How it is to be distributed, I don't think there is any procedure.
No.
And like 102 of old criminal procedure code, you will find that there is a seizure provision.
Yes.
Seizure of provision. The property can be seized, and for those property there is a provision of return of property.
Yes.
Under 454, 457, if you go to the old code of 1970, there were provisions. Here also there is an analogous provision to 102, but this is not similar to 102. This is an independent new provision they have incorporated in this particular legislation. Something called as attachment or forfeiture, attachment of properties, attachment of properties. And if the property is distributed, Now, one can understand under the MPID, the whole object is to see that the property is collected because the money is being invested by poor people, false promises were made, deposits were made, and they are required to, properties are attached, properties are sold, and the money is distributed amongst the investors. That is the idea of MPID. But that is not, that can't be in all these other offenses. For example, some vehicle has been recovered at forfeited, and it is sold, and ultimately if it is found that the accused is acquitted, we don't find any provision. At least in the light of 102 of the old code, even during the end of the trial, there is a provision of return of property. But there is no such provision as far as this.
Sir, if you could give an idea of what this provision is for our viewers at least, what is the difference between 102 and 105?
No, 102 is basically if it is found that any property is derived or involved in commission of crime, then 102 is been invoked and the property is seized, but there is a procedure that a report has to be submitted to the magistrate. This is the aspect of 102. This provision has been probably made in the light of, as you rightly said, what is incorporated in MPID and PMLA. Those are completely different acts. Forfeiture here, this is derived out of the proceeds of crime. Like person commits a theft and he receives money and he buys some property out of that. Probably that appears to be the idea. Because something which is derived out of the proceeds of crime. 102, the property is involved in the crime. Or there is a suspicion, reasonable suspicion that the property is involved in the crime. Under 102, it has been seized. But as far as this forfeiture provision is concerned, or attachment provision is concerned, it is out of the proceeds of crime, which has a different connotation. Like you have cheated someone and earned crores of rupees, and out of that, you have purchased certain property. That property can be attached. This appears to be the idea. But then, of course, the opportunity is also being given to the person against whom the action is sought, because 14 days show cause notice is provided. Show cause notice is provided under this provision. So this appears to be a major difference between what you will find in 102 and this.
Sir, just thinking out loud, like given a case where there's a civil angle and a criminal angle, suppose a landlord-tenant dispute, could the tenanted property also be attached in that if there's a criminal case pending?
Actually, it should not be, but one doesn't know how the police are going to interpret this provision.
Correct.
And one doesn't know why there was the necessity of incorporating this provision under the BNSS Act.
Sir, I had three small questions arising in this subject. Firstly, the earlier provision 102 CrPC, the Supreme Court clarified that the police can only attach movable and not immovable. Here, there is no such distinction. Secondly, there is no distinction about this provision being used for economic offences only or also other offences other than economic. And thirdly, the adjudicating process, as you rightly mentioned, that PMLA and PID have their own adjudicating process, unlike this. So in these three aspects, sir, need your views on what you feel is this.
Of course, as you rightly said, as far as 102, the movable property has been referred to. And that question had come for interpretation that Niyogi's case is their old case. As to whether which property can be attached, that law is very well settled. But here, there doesn't appear to be any distinction. But then, there is always a chance of misusing this provision.
Correct.
As to, there is a reason to believe. The investigating officer, one doesn't know what would be the reason. But of course, there are some safeguards are provided here. They are required to make an application, take the permission of the higher police authority, etc. But then, there is no provision to challenge this aspect. But then probably the only provision will be inherent powers under 482. If any order is passed under this 107, no appeal or any other provision is made in this particular act, the aggrieved person probably will have to exercise the inherent powers to challenge this. But there is a scope for misinterpreting and misuse of this particular provision. Because at the stage of investigation, what is there to show that this is the proceeds of crime? and the trial is yet to take place. At this stage, only investigation is going on. But at the stage of investigation itself, the investigating officer is going to take this step and is going to attach the property.
Yes.
So these are certain, probably there should have been more debate
Yes.
on this aspect,
Yes.
and some provisions should have been made.
So now, next topic is with respect to registration of FIR. The change which we have noticed is that now you can register an FIR and there is no bar of any jurisdiction. So
That is
what are your
called zero?
Zero
yes,
FIR.
sir. Yes, sir. So what are your views, and do you think that this will lead to more complications because there is no provision particular saying that once you register you have to transfer? It just says that you can register an FIR anywhere and it can be probably interpreted that that agency can only investigate.
No,
Place.
earlier what they used to do is, if the FIR is registered, then it is to be transferred to the concerned police station. But the idea probably of incorporating this provision is that in many cases you will find there are police stations who don't even register FIR. Otherwise, what should have been done? Suppose a crime is brought to the notice of the police. If you don't have jurisdiction, you registered it and signed it to the police station having jurisdiction. In some cases, that is being done. But in most of the cases, the aggrieved person, the victim, was required to run from place to place
Yes.
just to find out which is the police station having jurisdiction. Sometimes the issues come on boundary line.
Correct.
They have their own jurisdiction. Then the victim is required to from one place to another place, from another place to third place, and which consumes a lot of time, and probably because of the delay in the registration of FIR, sometimes it affects the evidence which is required to be collected against the person who has committed a crime. Probably that is the idea where this provision must have been incorporated. But since it doesn't mention about the after registration of the FIR, it should be transferred to the investigating agency, whether the same police station then will have to have the option of continuing with the investigation. So when the crime is committed far away, outside the jurisdiction, then they will have to go there, investigate, find out what is the evidence, collect the evidence, which the local police station having jurisdiction probably would be in a better position to investigate. So that those difficulties would arise in this case.
In fact, this appears to be one of the victim-centric provisions, like Sir said, because in the end, the jurisdiction does not matter, because this does happen many times. They say, "Do ikadna naka tikade dusra thanat ja," and then they just keep moving you from place to place, and the victim is helpless. So I think at the end of the day, having jurisdiction, even if though it's not within your territory, within your local limits, is something which is victim-centric at the end of the day, to register the FIR.
But then probably for investigating agency also it might create problem.
Yeah.
Suppose if it is registered at some place which has no connection with the crime at all, they would not be in a better position to actually investigate the crime effectively. So those difficulties also may arise in this. Let us see. at the time.
Also forum shopping. People may go to a more convenient place to register cases.
But the idea appears to be that the victims are made run from police station to police station.
Yeah.
But one rider they should have put up that
To
that after
transfer,
registration,
yes.
it should be transferred to the agency having jurisdiction to it. Now the same provision 173 also refers to preliminary inquiry.
Yes.
So this is something new.
Yes.
You will find.
So in fact, that was going to be my next question about 173.3. That we all know the Lalita Kumari judgment.
Yes.
And there specifically Supreme Court had given directions that even if the police if the police don't believe the cognizable offence has taken place prima facie, then they can conduct a preliminary inquiry and give a report and then determine whether there is some sort of cognizable offence or there is a requirement for registration of an FIR. This appears to be in furtherance of the Lalita Kumari directions, but I feel here there's an addition over here added that the police have to be prima facie satisfied that there is an offence.
But then there's a rider to this.
Yes.
This can be done in respect to the offences which are punishable more than 3 years but less than 7 years.
Yes.
But even then, of course 14 days time limit is given to them to register. But Lalita Kumari is a constitution bench judgment Of course, there it was said that once the cognizable offence is made out,
Yes.
it is the bounden duty of the investigating agencies to register the FIR immediately. This will give more, scope to the investigating officer not to register the FIR. He will conduct preliminary inquiry. Says prima facie case is not made out, etc.
Correct.
Sir, even one more provision which is just after this 175.3, which I think correlates to original 156.3. Now in this provision also, what they have done is that the magistrate who is supposed to give directions under 156.3 for registration of an offence or for investigation, he has to give a chance to the police officer to be heard. So why do you think that has been incorporated?
The role of the police would come after the direction under 156.3 would come. So how it has been mentioned here that the police has to submit the report, one doesn't know. It's not very clear.
Again, one more provision giving more power to the police.
Yes. In fact, the major change you will find, probably you would come to that also, about that right of audience given to the accused at the time of taking cognizance of a complaint.
Yes. We will.
This had never happened. For the first time, this has happened.
Yes.
And I think it is going to delay the proceedings. It looks like. So there is no question of giving hearing to the accused. When the complaint is filed, the court has to, if a private complaint is filed, for example, the court records the verification, unless the complaint is a public servant. Court records verification statement, and if the court is satisfied, the court has to issue process, take cognizance of complaint, or refuse to issue the process. But here, what is mentioned here, that in all these complaints, the accused has to be given hearing. The accused will come forward. Accused might say that this is a false complaint. Where is the question of the assessing the evidence which was brought before the court by the accused, and what is the nature of the material? The court is going to look into it when the accused is given audience. Otherwise, as per the old code, it's a settled law. There are various judgments of the Supreme Court that accused has no right of audience at the stage of taking cognizance of complaint. He's not in the picture at all.
Yeah.
And the settled law is also that at the time of taking cognizance of a complaint, the court is required to see prima facie case and then take cognizance or issue process. But what is going to happen by giving hearing to the accused? The accused will come forward, he will say that I am relying upon all these documents, this is a false case, etc. etc. So whether those documents can be looked into, then where is that the principle of looking into the prima facie aspect would stand?
Correct.
Because the accused would come with all his defense, and after hearing his defense, then the court probably would dismiss the complaint, for example. Where the complainant will have to go then and challenge that order before the higher court.
Yes.
And the defense of the accused, we always say, has to be looked basically most of the time during the trial, isn't it? If you are relying upon some document, these are your defense documents. Defense documents are basically looked into by the court when the trial commences, but not at a initial stage.
Correct.
And thereafter the court then, after hearing him, the court is satisfied, yes, there is a prima facie case, then the court will issue summons, process, take cognizance of complaint. Again, the accused will challenge before it to some other court, to the higher court, saying that this order has been wrongly passed when there is sufficient evidence to show that I am innocent, that there is no case made out against me. All these aspects, instead of, in fact, if the whole object of this law, new legislation, is to deliver speedy justice, then I don't think that this provision is going to achieve that object.
Yes. Also, so one more settled principle that a person becomes accused only after process is issued.
Correct.
Here you are hearing a suspected accused rather.
Similarly, there is another provision about in summons cases there was no provision of discharge.
Yes.
Correct.
Here there is a provision of discharge which is being made.
Yes, sir.
Otherwise, you know that this is a settled law that can't be discharged, and the magistrate has no power of recalling his own order. That is also a settled law. And therefore, in summons cases, the only remedy which was available to the accused is to challenge under 482 or file a revision application and challenge the order issuing process. But here, at the stage of taking cognizance itself, the audience is given to the accused, then it would create problems. Problem in the sense and it's going to take time.
Sir, having said all of this, what do you think could be the advantages or the pros of these provisions, especially 223, where the accused needs to be heard prior to the process being issued?
Probably the only idea could be is to give an opportunity to the accused to bring before the court the truth, because many times it is argued, this could be one of the idea, that the process is obtained by suppressing certain vital facts. And if the accused is given an opportunity to place his side, then at the inception itself the proceeding would come to an end. Instead of then taking cognizance and issuing process and then asking the accused to come before the court or to challenge those proceedings to the higher court, why not give an opportunity to the accused at the inception itself, and to see that whatever document he might produce or whatever he say, which he might bring before the court at a subsequent stage, is given an opportunity at the earlier stage, so that the proceedings would come to an end at the first stage itself. This could be the only idea. There's one more aspect to this. You see some provision where the victim is required to be informed about the status of the investigation.
Yes.
There's a provision incorporated in BNSS, where after the investigation proceeds, the victim or the informant has to be updated as to what stage the investigation is. That was not there earlier. And now the victim is being given. Now see, there's a definition of victim under this provision. Earlier it was under section 2WA. Here also there. But now there's slight change in the definition of victim. Earlier it was said that victim is a person who is aggrieved, or the kin or kith of the aggrieved person in respect to the act committed by the accused who is charged of offense, particular offense. That was the word charged of the offense now has been deleted in BNSS to avoid any complication.
Now, sir, coming to the next topic, which is, also a major change has been made with respect to the remand process. Now, for the viewers, so if you could explain the difference of what actually has changed in the remand procedure from the earlier code to now.
Now, if you see section 167, it refers to the time as to how much time a person can be remanded to custody, police custody. Now 167 as well as this new provision also refers to 15 days period in police custody. But there is a room for an argument in this new provision as to whether the investigating agency can ask for police custody for more than 15 days. There is a debate also, there was a discussion also as to whether this has given more powers to the police to keep the person in police custody, and the magistrate can extend it beyond 15 days. Now there are the section 167 and even 187 refers to two types of offences. All those offences which are punishable with death, imprisonment for life and up to 10 years, more than 10 years. And all other offences which are punishable up to 10 years. Now 167 mentions that 60 days and 90 days is a period which is provided for completing investigation. And the investigation is not complete and a charge sheet not filed, and a person is accused is entitled for default bail under section 167(2). Here also there is a reference of 60 days and 90 days. But then in 167, the second proviso clearly mentioned that the period beyond 15 days is clearly stipulated therein, saying that the custody other than the police custody can be extended. Now the word custody other than the police custody is not incorporated in this 187. If you see 167, the proviso clearly mentions other than 167. But further there is a reference of 90 days and 60 days. So therefore, subclause 3, my interpretation, will have to be read with subclause 2, where it is clearly said that 15 days in a whole. Therefore, although the word other than police custody is not incorporated in subclause 3, it would not empower the magistrate to extend it beyond 15 days.
In police custody.
In police custody.
Yes.
See, the whole idea of keeping the person in police custody for a minimum period is to avoid, that third degree methods or atrocities which the police carry out against the person who is in custody. So 15 days is the maximum period. But this difficulty has arisen because subclause 3, if you see 167, doesn't mention the word
Yes.
other than the police custody.
Yes.
But this has to be read along with 2, and then further 90 days and 60 days they have incorporated in subclauses of subsection 3.
Yeah.
So we'll have to read it as 15 days as a whole. But the question of interpretation is bound to come in some cases.
Otherwise, it may also mean that 90 days, 60 days can be police custody.
In fact, the grievance of in Parliament also this question had raised that whether this would mean that the person can be remanded to police custody for more than 15 days. And probably there was an answer that no, it is only 15 days. But merely saying it doesn't mean it's a question of interpretation of this provision. Someday, some issue will come.
Maybe you can argue it in Supreme Court next time.
But the issue will not come before me.
Through you, not before you, through you.
Yeah. And one of the major change also here in this 187 is, this 15 days can be bifurcated.
Yes.
15 days, today you have taken police custody of 3 days. You can again seek police custody of another 3 days, another 4 days. In total 15 days at a different point of time.
Before it was not like that.
Before it was not like that.
Before you could be only 15 days.
Yes.
First 15.
Yes.
So, but do you think this will hamper the bail? Like if I am remanded to JC, I file a bail application. Then again, if I am remanded to PC and my bail application is still pending. So, do you think there will be some dispute about that?
Definitely. You would not be able to know when your period of 15 days is going to come to an end.
Correct.
Because if you continue to be in police custody, generally the court doesn't grant bail. After police custody, the person is remanded to jail custody, then the inference is the police investigation is over. Custodial interrogation is over.
Yes.
Now there is no harm in granting a person, releasing a person. But if the custodial interrogation or police investigation is still going on, then why should it be released on bail? Therefore, in magistrate court, if you appear, you will find as soon as the person is remanded to judicial after the end of that 15 days, application for bail is required.
Correct.
But you never know, 3 days, 4 days, 5 days, when are they will be. This probably has been incorporated with an idea that, some of the accused, after they are arrested, they complain of, their chest pain and, all those health issues. Then they are hospitalized. And that period comes to end. Then the question arises whether at subsequent stage, they can be now remanded to police custody.
Correct.
All this probably the idea of the incorporating this provision.
But the bail thing will still be a tricky situation. When can it be filed? When can it be heard?
But at once the default bail right is protected.
Yes.
Because you will find further 90 days and 60 days.
No.
If the charge sheet is not filed, 90 days is for the offences which are punishable with death, life and more than 10 years.
Yes.
Up to 10 years, it is 60 days.
Yes.
So if the charge sheet is not filed within this stipulated time, a person has a right to make an application for bail, which is we generally termed as the default bail. And that right has to be exercised before the charge sheet is filed. Even if the 60 days period is over, for example, today it is over, tomorrow you have to apply for bail, 60 days or 90 days. If you don't apply, and on the next day the charge sheet is filed, your right extinguishes.
So now talking about timelines, now there are multiple, as we spoke in the beginning, there are multiple provisions with respect to discharge being heard within 60 days or charges being framed within 60 days and many other such provisions with respect to
a certain type of offences also.
Yes, certain types of offences of rape, etc. for timeline. So your views on whether these timelines are realistic and can be actually followed in letter and spirit, and moreover with the strength of judiciary, whether this is actually achievable.
See, the provision is being made, but it is doubtful whether it will be possible to practically implement this. I'll give you an illustration of Negotiable Instrument Act. See, the whole idea is to, at particular, incorporating the section 138, is to complete those proceedings within a period of 6 months. But the pendency of complaints under the negotiable instrument are so many that the first date for a matter is given after 6 months. Because it's not possible, practically not possible for the magistrate to hear all the matters, considering the number of matters, complaints which are pending. So many complaints are pending. So practically, although here it is, provision is being made, and attempt should be made to implement it. It has got an object of finishing the proceedings, disposing the proceedings as early as possible. So an endeavor should be made to see that it should be done within the stipulated time. But your question is whether practically it will be possible. One doesn't know.
So even there's a provision that rape trials should be concluded within 2 months. We see rape trials going on for like years.
Correct.
So those are also some new provisions which are added, but what the practical applicability of the same needs to be just tested
But at
with
least
time.
provision is that endeavor is made to see that as early as possible this type of cases or other cases also. Otherwise, what is happening is discharge application. The case comes for hearing after ages. Particularly if a accused is on bail, the priority is not given to those cases because obviously the court is required to give priority to the custody cases where the accused are in custody. And other matters come for hearing after a belated stage. And the applications for discharge are made when the matter is due for framing of charge. You must have noticed it.
Yes.
Charge is going to frame before the charge is framed because thereafter the court can't discharge it. An application for discharge is made. That takes a lot of time.
Yes.
Then application of discharge is made. The other side, prosecution will file a reply. They are going to seek time. Arguments are advanced. Sometimes lengthy arguments are advanced. Law point is involved. Judgments are cited. Sometimes the courts are also helpless.
Yeah.
But idea, at least provision is being made. Whether practically it will be possible to implement, we'll see.
Correct.
But at least endeavor should be made to see that the cases are disposed of as early as possible.
So, but
The main problem is, number of judges less than the number of cases.
So now talking about the bail laws, the earlier 436A for protecting the under trial accused, that half of the punishment they should be released on statutory bail. Now there is a one-third punishment.
It is made some benefit is given to the first time offender.
So, yes, sir.
If you see this provision, the first time offender, otherwise it is 1/2, correct? 1/2 of the punishment provided. If a person is in custody, he should be released. It's not termed as bail actually. 436A old provision, which is now
479.
479.
It is releasing a person. Bail provisions are the old provision 437, 439, all those which are now also here is also there. 1/2 of the punishment you have undergone, you should be released. The whole idea is that how long a person should be kept in custody. But even in that, some offences are very serious. Okay? And if you see that proviso to that right has been, there's a rider to that right. If the prosecutor makes an application, if the court finds that for the results to be recorded in writing, although the person has undergone 1/2 the punishment, even then he can be kept in custody for more period. That means he cannot be released. So that power has been given to the court. But the only difference here which you will find is, if a person has committed first time offence, then if he is in custody for 1/3, I think.
1/3.
1/3.
1/3 of them.
Then also he can be released. But this rider is there.
Yes.
But at least provision is there, a person can be released in case if he has undergone this much of it.
I think there are exceptions
Now
to
there's a issue had come up before the some court, before the apex court, that whether this 436A, which was the old provision, and now this is a new provision under BNSS Act, this can be made applicable retrospectively. But there are many people who are in custody. For that, we will have to go for that saving clause.
Yes.
Yes. Yeah.
The last provision in that.
Yes.
Yes. Sir.
So what is that saving clause? That if any appeal, application, proceedings, investigation is pending, then the old code will apply. if any notifications or anything, all those notifications are issued earlier, then the old code will apply. So therefore, whichever they are already there, proceedings which are already in force, then 73 code will apply.
Yes.
Now the question would arise, which provisions the BNSS should apply? Any offence which is committed after coming into force of this legislation, of course, definitely that new penal code would be applicable. Correct? New code of criminal procedure would be also be applicable. But for example, a person is facing the prosecution. He has been convicted. Okay? He is convicted today after this law has been brought into force. After BNSS came into. He was tried under the old code. He is convicted now. Alright? He is required to file an appeal. So which provision would be made applicable? This will be a question. Because the procedural law, question of limitation would come. A limitation that you are required to file appeal within limitation of law. Or suppose an amended provision gives more benefit to the accused person by preferring an appeal. Then such question would arise. Although he has been convicted as per the old code, but a conviction is now, and in the light of procedural aspect, whether the new act would be applicable or there also this 73 code would be made applicable. So this will have to be tested.
Looked into.
So, but the fact that they've used the word pending in the savings clause, that means any fresh proceeding, for example, the fresh appeal, shouldn't it ideally be under the new code, because it's not a pending case, it's a fresh appeal which I filed.
Correct. That's why I said. Then whether the new act would be, this BNSS act would be applicable or not, probably it may apply, this is a debate, the question would come.
Correct.
On that. But if the investigation is pending, because that saving clause protects the investigation, if the investigation is still going on, then the old code will be applicable. Then all those limitations, etc., investigation should be completed. Those old provisions of as to how to record statements, etc., those will be applicable of 1973.
Correct. So one more interesting thing about this: if offence is committed before July 1st, but not registered, and the crime is registered after July 1st, then which law would then apply?
This is also a question.
Yes.
That was going to be my question actually. Yeah, that is so true.
Because,
I think technically it should be from the date of registration of the offence, because since that day the criminal law is put into motion.
Yes. But it should be from, basically it should be from the date of registration of the offence.
Yes.
Anyway, but overall, if you see, I don't find there are major changes in the new legislation. If you see these provisions, probably this could have been dealt with by amending those provisions.
Correct.
If there was a major change, a new legislation was required. But considering this, the nature of the new provisions which are incorporated in the BNSS, probably those could have been dealt with by amendment also. But we are
not here today.
here to discuss this issue.
Yes.
It was, I am impressed with the questions and the discussion which is ensured by these two young lawyers.
Thank you, sir.
And it actually gave me an opportunity to express my views. Although, of course, whatever I have expressed may not be correct, but what I felt I have expressed. And both of you has studied this new legislation, and as the representatives of young generation, I wish both of you all the best.
Thank you.
Thank you very much.
Thank you so much.
Means a lot, sir. Thank you.